Today, I am reminded of a very interesting quote by American writer Mark Twain. He says, "If you don't read the newspaper, you're uninformed. If you read the newspaper, you are misinformed." Now, why did I start with this quote today? Because we're all glued to our screens and putting innocence through public trial every day, every minute. I'm sure you know by now हम सुशांत सिंह राजपूत केस की बात कर रहे हैं। जैसे ही कोई नई न्यूज आती है, कोई न्यू डेवलपमेंट सामने आती है, हम एकदम से अपनी राय बना लेते हैं and then we don't even bat an eyelid before changing our minds as soon as there is some other angle brought to light. Which begs the question, how fair is this trial by media? And what are the questions we need to ask ourselves to come to a sound opinion? To get our facts right, we will be discussing SSR's case from the legal standpoint with designated senior advocate Mr. Ashok Kumar Singh, who has a vast experience of over 40 years in both civil and criminal matters before the Supreme Court and High Courts of India. So today, for the benefit of our viewers, we'd like to understand three major aspects from you. First being the charges in the CBI FIR registered against Riya and her family. Second, the status of live-in relationships in India, and if Riya and Sushant's relationship can be considered a relationship akin to marriage. Third, if there is a need for restraint and sensitivity in media reporting in criminal matters under investigation. So coming back to my first question, the CBI FIR has multiple charges starting from abetment to suicide to wrongful restraint, wrongful confinement, theft, breach of trust, cheating, criminal intimidation. Some of these charges are extremely serious and non-bailable offences. So, sir, what are the material facts that prosecution will have to prove under each of these charges?
Thank you very much for this question. The Central Bureau of Investigation, as per the latest report, is assigned the responsibility to investigate the matter. Central Bureau of Investigation will not investigate on the FIR registered by the state police. Let us first understand what Central Bureau of Investigation (CBI) will do, and then I will come to charges. CBI has to register a regular case in their police station. CBI has to seize the documents from both the investigating officers. CBI has to look into the correctness of the FIR laws first. They have to confirm the veracity of the FIR contents. Then CBI has to look into all the statements which have been recorded. CBI will revisit it, and then CBI will look into whether a case which is according to complainant is made out or not made out. Initial investigation is to be carried on by CBI. Now we have the sections in which FIR has been registered. We have to look into what the prosecution has to prove. I will start with the most serious offense, which is section 306 IPC, which is there in the FIR. 306 IPC is abetment to suicide. For abetment, there are supposed to be two parties. Number one, a victim, and number two, a person who wants to abet. If a person is abetting it, then the first thing is required whether he has any motive or not. So to that effect, evidence is to be collected. Unless until he has a motive, he cannot abet. Second aspect which is to be looked into is whether the abetter, the accused, to achieve his goal, he wanted to follow the path of law or he wanted to achieve it illegally. So if you are able to achieve illegally, yes, it is an offense. Third evidence which is to be collected by the CBI is what positive acts were done by the abettor to achieve his goal and to harass to the victim. That is more important. And fourth is, was it a single act or a continuous act? Because a single act cannot be taken as to be an abetment. If the continuous act done by someone to achieve a goal illegally, then it can be a case of abetment. And ultimately the CBI has to come to the conclusion on the basis of the evidence collected whether the pressure built up by the accused was enough to pressurize and to push the deceased, the victim, to a stage where he thought that there is no other way except to commit suicide. So CBI has to collect the evidence on all these 5 points. Once CBI comes to the conclusion that evidence collected is enough in the court of law to show that victim was pressurized to that extent and harassed to that extent to achieve an illegal goal by the accused, that safely it can be said that the accused wanted that the victim either should go before or should finish his life. So then it will be case of abetment to suicide. But before abetment to suicide, CBI has to clear 3 other problems which would come in its way. It is a case of death and untimely death of a person by unnatural means. First thing which CBI has to also clear and prove and to collect evidence that it is not a case of murder. It is a case of only suicide. When CBI collection of evidence shows that it is not a case of murder by looking into the post-mortem report, then the second step would come into, because the person has died, either can be murder or it can be suicide. Then how suicide has been committed. CBI has also to collect an evidence whether the deceased, the victim, was a drug addict or not. If he was a drug addict, then to prove abetment, CBI will have to have little difficulty. And thirdly is whether he was hypersensitive or not. All these evidence are also to be collected side by CBI as far as the abetment to suicide is concerned. And it is the most heinous offence in the entire section which have been given, because it is punishable with 10 years RI, rigorous imprisonment, and fine. So for wrongful confinement, the CBI has to prove that he was compelled to remain in a room. He was virtually not permitted to come out of that. He wanted to come out of that, and the purpose was to achieve the malified goal of the accused. That was the purpose.
Yeah, and this is not the case with the wrongful restraint. In wrongful restraint, there's no other ulterior motive.
The wrongful restraint is when I have a right to go on a particular road, and you come on the way, say I will not permit you. This is now you are wrongfully restraining me. In wrongful confinement, I have a right to. I have entered into a room. I have a right to remain over there. I have a right to go out of the room also. But suddenly you came out and locked my room unlawfully. It is wrongful confinement. Or I have a right to come out of my house. You are standing outside with a threat that if you come out, I will shoot you. Then this is all wrongful confinement.
But you also said that to get something signed or to say that you're supposed to do XYZ things, otherwise will keep you confined. So that's part of wrongful confinement.
The allegation in the FIR is that gentleman, the Sushant Kumar Singh, he was taken from his house and placed into a resort against his wish. So once he was not inclined to be there in the resort, and he was not permitted to move from there. It is wrongful confinement. So this wrongful confinement, the CBI has to prove all these things. Then it will be a case of wrongful confinement. Wrongful restraint is a very simple offence. The punishment is 1 month, very simple imprisonment and the fine. But in wrongful confinement, the punishment is higher. Now the fourth section which is there is section 380, which is in the FIR. 380 is that you are committing a theft in some dwelling house, in some house, some room. Theft, everybody knows what is theft. Theft is that you are taking out or taking away some property without the consent of the owner. It is theft. It is theft. So allegations are that Ria and her family members have taken away all his property, jewelry without his consent. So CBI has to first prove that these were the properties of Sushant Singh. these properties were taken away by them without the consent of Sushant Singh, and obviously the CBI will also make an effort to recover those properties to give a strength to the case of theft. Unless until some recovery is made, the case becomes a little weak. So for that purpose, what is stolen, effort will also be made to recover that from the accused persons.
And sir, just to understand this a little better, of the things that we've already discussed, abetment to suicide, wrongful restraint, confinement, and theft, in this, how directly do these people have to be involved? Can this be done through another medium, through other people, or do they have to be directly engaged in these activities?
You are right, it can be got done. Suppose I am a person, I am an accused, or anyone is an accused, he wants to get it done, he can employ someone to go to his house, Sushant Singh house, and remove the property and keep into our property or our premises. That is also theft. That is, you are right, that is also theft. But in that case, the CBI will have also to take the action against the person who was assisting them in that process. It may be possible that CBI in these circumstances may add certain more sections like 120B, conspiracy, or other offences in case it is revealed in investigation that other offences were also committed by them. Now, next charge which is labelled by the family members is 406. 406 is criminal breach of trust. It is simple. If I have entrusted something with some direction to dispose of that property according to that direction, and that is not done according to that direction, and the accused use that property for his own personal benefit, or sell that property, or dispose of that property, that is the case of criminal breach of trust. So CBI will have to again look into and collect the evidence that there were certain properties, whether it was money, whether it was the money which was lying in the bank account, or the money which was lying as cash in the house, or the jewelry, or the other valuable things, they were entrusted to the crime accused, and they were directed, or they were instructed to utilize them in a particular way, but it was not done, and they utilized them for their personal benefits, and it was done illegally with a malified intention. The moment it is done, then 406 case also be beat out. Another charge which is under section 420 IPC. Now 420 IPC has got certain ingredients which are supposed to be proved. Allegation of 420 means that the party which has committed an offence, the accused which has committed an offence, that party give a misrepresentation to the victim in respect of fact which was not correct, and as such ask the victim to do a particular act which he would not have done if that misrepresentation was not given. It is like that I say that I am the owner of the house, you pay me 20 lakh rupees, I will sell the property to you. I have shown that I am in possession of the house. The victim, a person who has been cheated, he come under my misrepresentation. On the basis of my misrepresentation, he makes me the payment, and later on it is revealed that I am not the owner of the house. I was merely in a position of the house, maybe as a caretaker, maybe as a tenant, maybe a subtenant. So I have cheated to the person from who has given the money. So the CBI has to collect the evidence that there was misrepresentation given by the accused persons to Sushant Singh. On the basis of misrepresentation, Sushant Singh did some act which caused financial loss to him or other losses to him, and which he would not have done if this misrepresentation was not given. When all these ingredients will be proved, then the offence under section 420 IPC will also be.
Would you say there's a possibility of arrest in the meantime? Does that happen?
Normally is done by the investigating officer when enough evidence is collected, number one. Number two, accused is becoming smart, trying to destroy the evidence. Number 3, the accused is trying to run away from the country, or at least not obeying the instructions issued by the investigating officer. Under these circumstances, the investigating officer may arrest the accused and produce.
Thank you so much, sir. And I think a good advice for people in this time would be that they should cooperate as much as possible with the authorities.